announcements done. Papers have been laid. Question.
Honorable Leader of Opposition.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, I have given notice of the following private notice question addressed to the Honourable Minister of Industry, SMEs and Cooperatives, whether in regard to the compulsory requirement for businesses to register for value-added tax purposes upon making a turnover of taxable supplies exceeding 3 million rupees, he will state, A, if an analysis of the impact thereof on the small and medium enterprises sector has been carried out. B, the estimated revenue to be generated therefrom. C, the number and types of businesses concerned herewith. And D, whether government-held consultations and meetings with the stakeholders of the SME sector prior and after the presentation of the budget speech 2025-2026. Thank you, Mr. Deputy Speaker.
Honorable Minister.
Yes, thank you, Mr. Deputy Speaker, sir. I would like to thank the Honourable Leader of Opposition for this question, as it will give me the opportunity to explain the budgetary measure of reducing the compulsory VAT registration threshold of taxable supplies from 6 million to 3 million. We need to put some order in our public finances. This government is fully committed to a responsible approach to a fiscal stewardship under the able leadership of our Prime Minister, Dr. Navin Ramgoolam. In view of the disastrous state of public finances that we inherited, our top priority is to bring down the budget deficit and public sector debt to sustainable levels and ensure medium-term macroeconomic stability, and at the same time doing our utmost best to prevent any downgrade by Moody's, which some tend to underestimate. Mr. Deputy Speaker, sir, regarding part A of the question, I am informed that an analysis was carried out at the level of the Ministry of Finance in collaboration with the Mauritius Revenue Authority regarding the number of persons, by persons I mean individuals and enterprises, with turnover below 6 million rupees that may be affected. Mr. Deputy Speaker, sir, at the very outset, I wish to point out that VAT is levied on the supply of goods and services and not on enterprises. I would also like to clarify that only those businesses making VATable supplies above 3 million rupees, that is goods and services on which VAT is applicable, will have to register. Those businesses making non-VATable supplies are not concerned with this measure, even though their turnover exceeds 3 million rupees. For example, fresh vegetables, fruit sellers in the market, fishmongers, butchers, whatever, just name it, they are not concerned with these measures. That is, we are talking about fresh products. VAT is a tax on consumption. It is not imposed on businesses. In fact, one of the principles of VAT is that the VAT system is neutral to a VAT-registered business. By joining the VAT system, the new VAT-registered businesses will be able to recover VAT paid on inputs used, that is on raw materials, semi-finished products, as well as equipment, machinery in the production of goods or provision of services. Presently, a non-VAT registered SME are not able to recover VAT paid on input and are therefore passing it on the VAT paid on inputs to consumers. Mr. Deputy Speaker, sir, let me elaborate on the advantages that an SME will benefit from being VAT registered. Firstly, as I mentioned earlier, the SME will be able to claim a credit for input tax suffered. In case an SME incurs capital expenditure, for example, on acquisition of machinery or goods vehicle, it will be even entitled to a refund of the whole amount of VAT paid, that is, whatever the amount that has been paid for the purchase of this asset. Secondly, by getting registered, the SME importing capital goods, and where the VAT exceeds 150,000 rupees, they can obtain a significant cash flow benefit by not having to pay the VAT input at customs on importation under the existing provisions of the VAT Act. But this government, in 2025 and 26 in our budget presented by the Prime Minister, this VAT threshold has been lowered to 75,000 rupees. What does this mean? For example, when importing capital goods for a value of 1 million rupees, of which 150,000 rupees of VAT, which was applicable, was not payable at customs. Now, this threshold has been lowered to 500,000 rupees. That is, when you import a goods of capital nature, VAT of 75,000 rupees is not payable at custom. That is, you don't need to pay it and claim it back to the MOI. Thirdly, VAT registration can create business opportunities for SMEs. It is a known fact that many VAT-registered persons only work with VAT-registered entities in order to be able to obtain a VAT invoice and claim input VAT in their VAT return. Hence, being VAT registered may open new doors for SMEs. And fourth, at the national level, the reduction in VAT registration threshold creates a level playing field and fair competition among operators in the same business activity. It addresses the discrimination whereby a VAT-registered business with a turnover threshold slightly higher than 6 million is charging VAT, while a business which turnover slightly lower than 6 million was not charging VAT on the same types of goods, and encourages formal record keeping and improved tax compliance. It is noted that Mauritius has one of the highest VAT threshold as a percentage per capita. What does that mean? For instance, you will be surprised to know, for much bigger economies like India, Canada, Australia, South Africa, and Kenya, the threshold is less than 3 million rupees. It is between 1 and 2.5 million rupees. Like, for example, for South Africa, it's 1 million rand. So the threshold that we have in Mauritius, as I said, compared to other countries, much bigger economies, are higher than others. Regarding Part B and Part C of the question, I am informed by the Ministry of Finance and the Mauritius Revenue Authority that the additional revenue would be approximately 1.9 billion rupees from about 6,900 business operators, as follows. For those turnover from 3 to 4 million rupees, there will be 2,775 new registrants with an estimated additional VAT of 634 million. Turnover between 4 to 5 million, there will be new entrants of 1,958 new registrants with an estimated additional VAT of 570 million. And for turnover between 5 to 6 million rupees, there will be 2,166 new registrants with an estimated additional VAT of 787 million rupees. I would like to highlight that currently there are some 8,468 businesses having an annual turnover of less than 6 million rupees has already registered themselves on a voluntary basis. So this is something not new. 8,000 businesses which were not qualified for this threshold, they have registered voluntarily, as I said earlier, due to the various benefits of VAT-registered person, as I have mentioned. Regarding the type of businesses that need to get VAT registered, it is to be noted that VAT is based on two criteria. Namely, whether the business is engaged in making taxable supplies, that is, sells products which are subject to VAT, and secondly, the turnover threshold. Any business in any type of activity which meets these two criteria will have to be VAT registered. As I said, there are some exclusions. Mr. Deputy Speaker, sir, I am also informed that the majority of the additional proceeds from lowering the VAT threshold will come from operators engaged in sectors such as trading, manufacturing, accommodation, and construction. Regarding Part D of the question, I am informed that in the context of the budget preparation 2025 and 26, the Junior Minister of Finance held consultation with various stakeholders, including SME chambers, Manufacturing Jewelers Association, Association of Furniture Manufacturers, and Small and Medium Enterprises Federation, and also Association of Small Contractors, Association of Leather and Leather-related Products, and SME Mauritius on the 9th of April 2025. However, given the budgetary measure concerns a tax issue, obviously this was not discussed with them. I am given to understand that this is a practice insofar as tax measures are concerned. Mr. Deputy Speaker, sir, since I have assumed office prior to the budget speech, I have had meetings with SME chambers and SME Federation where I had lengthy discussions on challenges being faced by SMEs. I am in contact with the SMEs and various stakeholders, and I remain open to their suggestions and will give due consideration thereon. I have taken cognizance of the concerns by SMEs, and my ministry is working closely with the Mauritius Revenue Authority in order to come up with means and ways to simplify the implementations of this measure for the benefit of SMEs. As you are aware, the Ministry of Finance is currently preparing the Finance Bill, and if any adjustment would be required, it would be addressed thereto. Mr. Deputy Speaker, sir, this reform is a calibrated and responsible measure in response to an economic emergency. It reflects our commitment to shared recovery. We are not targeting SMEs, we are empowering them to participate fully and fairly in rebuilding Mauritius.
Thank you. Honorable Leader of the Opposition.
Thank you, Mr. Deputy Speaker. Sir, first of all, let me thank the Honourable Minister for providing the House with this information, not only the House, but the population, because he did not intervene during the debates on the budget. Now we have more information. Mr. Deputy Speaker, sir, here we are talking about small businesses, small family businesses, and very often run by the wife or the husband in the family. Can the Honourable Minister confirm if this budgetary measure will constitute a burden on these small businesses who will not only have to pay taxes but recruit professionals, for example, accountant to do their books? The Honourable Minister himself is an accountant by profession, and he knows very well what I'm talking about.
I thank the Honourable Leader of Opposition with coming with such concern, because we have already catered. We are addressing this issue because I agree that it is an issue. The MRA, the Mauritius Revenue Authority, how do we intend to assist SME in this registration process. There will be a special SME desk that will be set up to attend queries to SME in relation to VAT registration, record bookkeeping, invoicing, submission of VAT returns. Secondly, the MRA will publish leaflets and brochures to provide detailed guidance on getting registered. Now, with the filing, a simplified VAT registration process will be introduced, and simplified recording keeping requirement will be put in place, and also businesses having thresholds between 3 to 6 million, they won't be required to file monthly tax returns, but rather quarterly tax returns.
Leader opposition.
My second question, Mr. Deputy Speaker, sir, is to ask the Honourable Minister whether he will confirm that this measure will have a cascading effect on prices practiced by these businesses, as the additional amount that we will have to pay will be passed on to the customers.
Mr. Deputy Speaker, it is not necessarily true that there will be a cascade of increasing prices, because the SME, it will be able to recover the VAT paid on inputs, that is, on raw materials and capital goods. And before we had this threshold, the input VAT that the company, the enterprise was paying when we were buying their raw materials, their input, it was already passed on through to the customer. Now they would have a mechanism to offset the input VAT against the output VAT.
Leader opposition.
But I do not totally agree with the Honourable Minister. The SME sector, Mr. Deputy Speaker, sir, is the backbone of our economy, and today employs more than 50% of our workforce. Can the Honourable Minister confirm that there is a possibility that those businesses might consider downsizing their personnel?
I don't think so. I don't think so, Mr. Deputy Speaker. Why? Because you know what SMEs benefit when they are registered as SMEs with SME Mauritius. I will give you examples. And I will say frankly, I've been in Parliament since 2010. Even me, before joining the cabinet, I was not aware. I've been around the island with awareness program, and I have been ventilating all the benefits that SME Mauritius, which we have enhanced during the last budget. I will give you some example, some quick example, just to not to take the time of the House. In spite budgetary situation, when a company is converted to an SME company that is registered with SME Mauritius, provided their turnover does not exceed 30 million rupees, they are being given a tax holiday of 4 years. 4 years tax holiday. Secondly, Mr. Deputy Speaker, sir, for an SME, the road tax for an SME, registered one, instead of being 17,500 rupees for road tax for a double cab, an SME pays 5,000 rupees. Thirdly, Mr. Deputy Speaker, sir, SME benefits from duty-free facilities on double cab and pickup every 5 years. And also, more interesting is that no land conversion tax payable where an application is granted for the purpose of relocation, expansion, or setting up of an industrial enterprise by the holder of a registration certificate issued under the SME Act. And I can go on with investment tax credit for small businesses. I can go on with reserve contract margin of preference for SMEs, and also in the last budget, mention has been made for startups and SMEs will be able to claim tax deductions on their investment in AI technologies up to an amount of 150,000 rupees. So there are so many advantages, so many help that government is giving through SME Mauritius so that SME can carry on with their activities.
Honourable Leader Bush.
Thank you, Mr. Deputy Speaker. Will the Honourable Minister confirm that with this budgetary measure, some of those small business owners will try to avoid being VAT registered by not declaring their turnover above 3 million rupees, therefore creating ce qu'on appellerait une économie parallèle in the country?
Mr. Deputy Speaker, for those who does not want to declare their revenue, they don't have to wait for the threshold from 6 million to become 3 million to do it. There will still be some people who will not do it, but there are laws in the country, and MRA are fully equipped to address this issue.
With regard to those SMEs which have adopted the label Made in Maurice, will you reassure the House that such a measure will not affect those SMEs?
As I said earlier, I give example of fresh foods, fruit, vegetables, fishmongers, fruit sellers, butchers. All these are made in Mauritius. Not at all. They are not even ils ne sont pas concernés par cette mesure.
Yes, Honourable Leader Bush.
Can I refer the Honourable Minister to paragraph 28 of the annex to the budget speech? Can the Honourable Minister inform the House of the rationale for hairdressing services to be zero rated?
Do you have an answer?
I know that the Honourable Leader of Opposition is not concerned with this measure, but I will tell him that this measure will enhance, especially women in business.
Honourable Joel.
Thank you. May I ask the Minister, is the government prepared to exempt snack vendors and other food sellers from VAT registration under the new threshold? Because now most of them will fall under that, under the new threshold of 3 million, given that in their case they have very little input VAT. You said it yourself. Most of the raw materials, the poultry, the rice, the flour, the gas, the oil is zero rated, whilst the other bulk of the expenses, the labor, the fuel, is not deductible. So that will lead inevitably to at least 15% increase in the cost of food prepared and sold by food vendors, which will affect the general, public. So this will lead, unfortunately, à une augmentation du coût de la vie déjà directement impactée par ça. Et ça concerne des centaines de milliers de Mauriciens. Is he prepared to exempt those persons from this new lowered threshold?
Mr. Deputy Speaker, sir, as I said earlier, that in what kind of economic situation we are today. It's not, on est en train de faire ça pas avec gaieté de cœur, but there is a necessity, there is an economic necessity which, unfortunately, the last government has given us as inheritance.
Honourable Leader Bush.
Mr. Deputy Speaker, sir, thank you. In the same vein, this is the second time I'm asking this question. With regard to the small pleasure craft operators which have been forced through this budget to become VAT registered, may I ask the Honourable Minister how he reconciles this very unfair decision towards that category of entrepreneur, while at the same time encouraging Mauritians to become entrepreneurs. And we know that this measure will affect the tourism sector, Mr. Deputy Speaker, sir.
Mr. Deputy Speaker, there is not only this sector. We can argue that there will be this sector, that sector. You just can't pinpoint one sector. But as I said earlier, it's a decision of government which we had to take with difficulty, but we know that there was no choice for us, because we could have done one thing. We increased the base so as to have more revenue, but we could have increased VAT. Then all these what you are saying would have been accepted. But we had a choice to make. And we all know increased VAT, it's a tax on the poor. Because everyone, tout le monde va être frappé. So we had a choice to make, Mr. Deputy Speaker.
Thank you. No more questions. Thank you. So we go.
Question.
Honorable Prime Minister.
Mr. Deputy Speaker, I beg to move that all the business on today's order paper be exempted from the provisions of paragraph 2 of Standing Order 10.
Seconded by the Deputy Prime Minister. The question is that all the business on today's order paper be exempted from the provisions of paragraph 2 of Standing Order 10. Those in favor say aye. Those against say no. The ayes have it.
Statement by Minister.
Speaker, with your permission, I wish to make a statement concerning the reform of the basic retirement pension. The reform is to gradually raise the eligibility age for the old age pension from 60 to 65 years over 5 years. I want to speak directly and honestly to all Mauritians who look to this government for leadership in difficult times. First of all, let me repeat again. There is utter confusion in the mind of many people between what is a contributory pension and a non-contributory one. A contributory pension requires the beneficiary to pay into the plan from his salary, like occupation pensions. In a non-contributory pension plan, the beneficiary does not contribute for the benefit he receives. The BRP is a non-contributory pension. There is no contribution from beneficiaries. It is funded from the consolidated fund. As a compassionate government, we have heard the voices of the people, we have listened to the concerns, and have acted on them as far as possible, because the danger for the country, it is not being exaggerated, it is real and it is dramatic. Let me once again assure the House and the population that the government has not taken the decision to reform the basic retirement pension lightly. We have acted out of necessity, not out of choice. Let me recall some of the reasons that have motivated our decision. First, the cost of basic retirement pension payment has become explosive and is unsustainable. BRP spending in Mauritius has soared from 1.9% of GDP in 2010 to 7.8% in 2024-25. Basic retirement pension expenditure alone would be 55.4 billion rupees this fiscal year. It has almost doubled in 4 years, Mr. Deputy Speaker. It will reach 100 billion in 2035. That is clearly unsustainable. Second, demographic pressures are aggravating the cost of implication of the BRP. Mauritius, as we know, has an aging population and a declining birth rate. The population aged over 60 and above has grown substantially from 186,400 in 2015 to 257,600 in 2024. It will continue to grow as the population ages, and it will reach around 315,000 in 2038. As a result, without any reform, the cost of basic retirement pension on the government budget will exceed 100 billion rupees. Third, as a result of the demographic trends, the ratio of active workers per retiree has plummeted from 7 in 2000 to 3.9 in 2015 and to 2.7 today. and it is expected to drop to 2 by 2035. This means fewer workers supporting more retirees, placing immense strain on public finances. It is a fact that when the number of workers is much higher than the number of older retirees, the basic retirement pension system is relatively sustainable. But when the number of workers shrinks and the number of old age pensioners soars, the system becomes fiscally unsustainable and financially unbearable. Fourth, in the last 14 years, spending on old age pension has ballooned by a staggering 828%. Fifth, Mr. Deputy Speaker, the financial legacy of the previous government is in an unbelievable mess with very high budget deficits, rising borrowing requirements, and a mountain of debt for future generations. The country's financial resources are therefore stretched to the limit and has reached the tipping point. The current pension system, if left unchanged, is simply not sustainable. The situation is such that without reform, we risk a future where there will be no pension at all for any retiree, neither today's retirees nor those of tomorrow. As a responsible government, we could not stay indifferent to such a threat to our society, and particularly to the elderly of our nation. We therefore consider it as a solemn duty of government to ensure a strong and reliable pension system for generations to come. This is why we have chosen a phased approach, raising the eligibility age by 1 year at a time, starting with 61 next year until we reach 65 in 2030. This gradual transition is designed to give families time to adjust and to avoid sudden hardship for those nearing retirement. Mr. Deputy Speaker, we're not alone in this challenge. Across the world, countries are raising retirement ages in response to longer life expectancy and financial pressures of supporting a growing elderly population. Our reforms are in line with global best practice, but we have tailored them to our unique circumstances, mindful of our people's needs and of our nation's values. But let me be clear, Mr. Deputy Speaker. Compassion and responsibility must go hand in hand. We are doing reform because there is no choice. There is absolutely no choice. That is why we have set up 2 interministerial committees to look into the matter and to balance compassion with responsibility. In the interest of time and expediency, we have merged these 2 committees. Mr. Deputy Speaker, after careful analysis of all the facts and figures, government has decided that some families deserve support until they are eligible for the basic retirement pension, which is according to the reform. Government has decided, therefore, to provide an income support of 10,000 rupees per month to persons who reach the age of 60 years as from the 1st of September 2025. These persons will be eligible for the income support provided that A, in the case of a person who is single, his or her monthly income does not exceed 10,000 rupees, or in the case of a person who is married, the monthly household income does not exceed 20,000 rupees. For a single person, the monthly income will include emoluments, income from business or profession, and contributory retirement benefits, but it will exclude lump sum payable on retirement and other benefits, including the invalidity allowance provided by the Ministry of Social Integration, Social Security, and National Solidarity. For a married person, the monthly income will include emoluments, income from business or profession, and contributory retirement benefits, but it will exclude the lump sum payable on retirement and other benefits provided, including invalidity allowance, provided by the Ministry of Social Integration, Social Security, and National Solidarity, as well as the basic invalidity pension, the income support in lieu of the BRP, or the BRP being drawn by the spouse. Most of the beneficiaries will be housewives, retirees, employed and self-employed that meet the criteria, which is larger than the initial criteria of focusing on sectors with difficult working conditions. On average, there will be some 7,500 eligible beneficiaries per age group annually over the next 5 years, which represents around 46% of those turning 60. This special effort made by government will cost some 8.7 billion rupees over the next 5 years. The Mauritius Revenue Authority will be responsible for the payment mechanism. Beneficiaries will have to submit a one-time application for the income support to the MRA unless there is a change in circumstances. The income support will be credited directly in the bank account of the beneficiaries, and payment is expected to start on the 1st of September of 2025. Mr. Deputy Speaker, in parallel, we will carry out a holistic review to improve the invalidity pension system, which will start in the coming days. Furthermore, as announced in the budget, a commission of experts will be set up to look into the reform of the 3 pillars that constitute the pension system, as well as revamping of the National Pension Fund to replace the contribution sociale généralisée. The terms of reference of the Commission are being worked out, and the chairperson and members of the Commission will be appointed very soon. Mr. Deputy Speaker, our decision has been guided by the need to balance social coherence and fiscal stewardship. While our decision favors our deep commitment to social justice, we have ensured that at the same time that our roadmap to fiscal consolidation is not jeopardized. It has been a tough balancing act, but in the end we are confident that we will, with the cooperation and understanding of one and all, take our country safely to port. Thank you.
Public Bills, second reading.
Honorable Attorney General.
Mr. Deputy Speaker, I move that the Revenue Tribunal Bill number 12 of 2025 be read a second time.
Seconded.
Mr. Deputy Speaker, I shall keep my remarks short and focused. This bill aims neither to widen tax powers nor to invent new causes of action. It does one thing only. It replaces the Assessment Review Committee, currently provided for in Section 18 of the Mauritius Revenue Authority Act, with a Revenue Tribunal, and this with a clear purpose in mind, rationalizing and modernizing the process with the necessary checks and balances in order to have a more just, accessible, and comprehensive system. That shift may look modest on paper, yet it answers concrete shortcomings that practice has made impossible to ignore. I will outline those shortcomings, explain how the bill deals with each, and show why a new legislation instead of simple amendments was the only satisfactory route. The Assessment Review Committee, Mr. Deputy Speaker, sir, created in 2006, has indeed performed valuable service. Its composition placed experienced barristers in the chair and paired them with members drawn from accountancy, economics, and taxation. It could sit in flexible panels, and from 2022, it even gained power, subject to the consent of the parties, to reconstitute a panel that lost one of its members before the case is over. None of that is being discarded. The new tribunal still has the Public Service Commission as appointing authority for its legal members and preserves the requirement that lay members bring specialized financial expertise and remain independent of the public service or the MRA. But we needed to go further. Experience has revealed 4 structural obstacles which the existing committee, because of its very nature as an emanation of the MRA's statute, could not overcome. First, institutional independence. The main function of the Assessment Review Committee is to hear and determine representations made by any person who is aggrieved by a decision, determination, notice or claim of the Director General of the MRA or of the Registrar General. However autonomous and unbiased the Assessment Review Committee may be, it remains conceptually part of the authority whose decision it reviews. Therefore, in view of the quasi-judicial nature of its functions, it is considered more appropriate for such functions to be discharged by a fully fledged tribunal along the same lines as other existing administrative tribunals, such as the Employment Relations Tribunal, the Environment and Land Use Appeal Tribunal, and the Public Bodies Appeal Tribunal. The Revenue Tribunal will be a standalone body established by its own act, with its own secretary and staff working under the chairperson's administrative control. That separation is not cosmetic. It speaks to public confidence, particularly among foreign investors accustomed to seeing revenue disputes being handled outside the revenue agency's statutory framework. It puts the new tribunal at par with other quasi-judicial bodies, which I referred to earlier, which are entrenched in the minds of the citizens as checks and balances to the exercise of executive power. Second, procedural certainty. Per Section 20, subsection 3 of the MRA Act, the committee, the ARC, endeavoured to fix hearings within 3 months and to issue its decisions within 6. Such good intentions too often slipped, sometimes because complex interlocutory matters consumed the calendar. The bill transforms these aspirations into legal obligation. Clause 7 now mandatorily requires the tribunal to schedule a preliminary hearing within 120 days of lodging and deliver its determination within 90 days of the close of evidence, a period which may be extended only in exceptional circumstances and only with the consent of all parties. The timelines are thus shorter, clearer, and enforceable, and practitioners will be free to plan and taxpayers budget around a reliable procedural calendar. Third, the scope of appeals. Under the present Act, a party dissatisfied with the decision of the ARC may go to the Supreme Court only on a question of law, via an outdated process of asking the ARC to state a case. That narrow gateway means that an error of fact, for example, an arithmetical slip or a mistaken reading of a ledger, cannot be corrected on appeal. Clause 1 removes that artificial constraint. Appeals will follow the ordinary civil route used for district court judgments, allowing the Supreme Court to examine both fact and law. The change neither widens nor narrows tax liabilities. It simply ensures that mistakes in the appreciation of facts of whatever nature may be rectified. Accordingly, an appeal to the Supreme Court will now also be assessed on any factual evidence adduced before the Revenue Tribunal. Fourth, alternative dispute resolution. The current system relied on separate alternative tax dispute resolution panels. Those panels have been now repealed, and the bill closes the gap by weaving mediation into the tribunal's own fabric, where both parties ask for it. The chairperson will refer the matter to a mediation panel consisting of a legal member of the tribunal and, where appropriate, another member. Any agreement reached will be recorded as a final, binding determination, and if none is reached within 90 days, the case reverts to the tribunal without prejudice. The taxpayer therefore gains a voluntary, confidential avenue that can conserve both resources and goodwill. This bill also codifies matters that until now depended on implication or practice. Clause 9 states expressly that the burden of proving that an assessment is wrong or that a tax has in fact been paid lies on the person disputing the charge. Clause 12 creates specific offences for refusing to attend or for giving false evidence, with penalties of up to 100,000 rupees and imprisonment. Those provisions do not invent new duties. They place existing judicial expectations beyond doubt. Conversely, the bill abandons what is no longer needed. The key performance indicator regime, whereby the Minister of Finance, sets annual targets for the committee, is not reproduced. The independence of the tribunal means that it must enjoy freedom from ministerial control and notation, subject to the requirements of the legislation. And a word on transition now, Mr. Deputy Speaker, sir. Clause 18 provides that every matter already opened before the committee as it stands today and still pending on commencement day of this legislation will be taken over by the tribunal exactly where it stood at the time. Parties will not have to free file and fees already paid will be carried forward. In short, no litigant will be disadvantaged by the structural changes. Mr. Deputy Speaker, sir, to recap in broad strokes, this bill contains 4 clusters of clauses. First, the machinery itself, clauses 1 and 2, supply the preliminaries. Clauses 3 and 5, 3 to 5 create the tribunal, set its membership and staffing. Second cluster, the hearing process, clauses 6 to 10, preserve the 28-day appeal window, lay down full procedural instructions with firm timelines, take evidence on oath unlike before the ARC, build in mediation, place the burden of proof on the appellant, and spell out the tribunal's power to confirm, amend, or quash a revenue decision. Third cluster, supervision and enforcement. Clause 11 opens appeals on fact and law to the Supreme Court. Clauses 12 and 13 set offences for obstruction and give members statutory immunity, whilst Clause 14 and 15 authorize regulations and rules of court. Finally, the fourth cluster, consequential matters. Clause 16 repeals the ARC from the MRA Act. Clause 17 updates 10 related enactments. Clause 18 moves pending ARC cases straight to the new tribunal. Clause 19 deals with commencement, and the schedule lists every revenue law that will now fall within the tribunal's reach. Mr. Deputy Speaker, sir, fair taxation implies fair adjudication. The design before the House retained what has worked: a professional bench, specialized members, flexible panels. And it corrects what has not worked: institutional dependence, elastic timelines, an unduly narrow right of appeal, and the absence of a modern mediation track. It does so through an instrument that does not make the tribunal a subsidiary of the authority it reviews. That is the entire logic of the bill. It is a small step in the vast modernization process which we are bringing to consecrate the rule of law and make justice more accessible and efficient. Mr. Deputy Speaker, sir, after the bill was introduced to this House, we received some further proposals from members of the Assessment Review Committee, some of which have been taken on board and some of which we did not, as we deemed them superfluous. They are mainly with regard to some cross-referencing in other legislation and to bring clarity in some provisions of the bill. We have already circulated the amendments, which are only technical in nature, and I will move for these amendments at committee stage of the bill. With these words, Mr. Deputy Speaker, sir, I commend the Revenue Tribunal Bill to the House.
Thank you. Honourable Narsinghan.
Thank you, Mr. Deputy Speaker. I'm intervening today to support the Revenue Tribunal Bill. This is a transformative piece of legislation that heralds a new era of fairness, efficiency, and transparency in the resolution of tax disputes in our Republic. In fact, it is to be noted that there has been a backlog of cases, and this bill, as rightly pointed out by Honourable the Attorney General, aligns tax dispute resolution with international standards as prescribed by the OECD and other international organizations and other countries where we have borrowed best practices. Mr. Deputy Speaker, for too long, taxpayers, businesses, and other stakeholders have voiced legitimate concerns about the complexities, delays, and procedural shortcomings inherent in the current dispute resolution framework under the Assessment Review Committee. The bill today responds to those concerns with conviction and clarity. In fact, during the electoral campaign, the Prime Minister and many members present have also promised to address genuine criticisms which were addressed to our taxation system. You still remember these criticisms. So in a society, in fact, a fair and delicate balance has to be struck between the interest of taxpayers and the state, that is society at large. I should recall the jurist and philosopher Roscoe Pound, who explained the idea of dual postulates in a given society, and how we as policymakers must reconcile competing interests in a society, and this is what we are doing today. This is what has been done by the Attorney General and the present government, and this work has to be fully commended. Now, what we have today, Mr. the Deputy Speaker, we have a modern and independent tribunal. First and foremost, you will see that Section 3 of the bill establishes a revenue tribunal as a fully independent statutory body. So now, as pointed out by the Honorable Attorney General, we have a stand-alone legal framework distinct from the MRA Act, and this is very important because now this will dispel any doubt on the lack of strict separation of powers and duties, and to do away once for all with bias. Now, Mr. the Deputy Speaker, it's not only bias, but also the perception of bias, and this is very important. So unlike the ARC, which was nested within the MRA framework and the sections 18 to 21 of the MRA Act, now we have a distinct entity, and it is to be noted, very important, that the tribunal shall be composed of legally qualified and experienced professionals, and as from now, with the new legislation, the chairman should be a barrister reckoning 10 years of experience, and the vice chairman should reckon 5 years of experience. Now, experience is of essence. You know very well, honorable members, that in the legal profession, when you start the profession, you have to grapple your way. It takes you, on average, around 5 years to know where you want to go. And I consider that somebody with 10 years of experience is very, very important. Possibly, I'm just suggesting, possibly we could have added that 5 years of experience, general experience, but also 5 years of relevant experience in the field of taxation. Because you will understand, somebody can be an outstanding barrister in criminal matters, not necessarily in taxation, and tax law is something which is very, very complex. So a barrister, only after that period, we can focus on specific areas. So the new section represents, I would say, a monumental shift towards institutional impartiality and judicial independence, as well as the hiring of a chairperson with considerably more legal experience. Now, another important point, Mr. the Deputy Speaker, you will see there is the element of timeliness and efficiency. And one of the most commendable reforms introduced by the bill is the imposition, this time, of statutory deadlines. And you will notice that under Section 7, subsection 7, the tribunal must fix a preliminary hearing within 120 days of the appeal being lodged and render its decision, this is very important, within 90 days of the close of the hearing. And this is, in fact, a far cry from the previous regime under the MRA Act, where delays of 6 months or even were the norms. And deadlines were only, I would say, aspirational at best and not mandatory. And there was too much flexibility, as pointed out by the Honorable Attorney General. And this is, in fact, not appropriate for the business world. And at the same time, what we noticed, there was only a best endeavor standard. So there was a sort of illusion, and many people could exploit the system and use dilatory tactics, unfortunately, and this is why we ended up having such a very important backlog of cases. And what we notice also, Honorable Deputy Speaker, honorable members also, the tribunal is not, this time you will find out, very important to put that on record, is not a toothless forum as it used to be. Under Section 7, subsection 5, this time it is vested with what I would qualify as court-like powers, that is, the ability to summon witnesses, compel production of documents, administer oaths, which is very important, unlike the current law. So this was not so under the purview of the actual law which we have. Now, such powers, you will understand, ensure the proceedings, that the proceedings are conducted rigorously with due regard to the rule of law and also evidential standards. And very important to note, Honorable Deputy Speaker, you will see that frivolous and vexatious revenue appeals under the law may be dismissed now outright by virtue of Section 10, subsection 5. And also very important to note that this time, the tribunal may award cost with appropriate strong, which is in a way a strong deterrent to abusive litigations. What is also important, as pointed out by the Honorable Attorney General, there has to be a fairness in procedure and evidence. And a critical safeguard is introduced, you will see, in Section 9, which provides that documents or evidence not disclosed at the objection stage shall be inadmissible unless the party shows good cause. And this promotes procedural discipline and deters last-minute litigation ambushes. Moreover, you will see also, and this is a very important point, the burden of proof has been expressly codified this time, as pointed out by the Attorney General. While it is generally, the burden of proof generally lies on the taxpayer, you will note that this time, Section 9, subsection 4, rightly shifts the burden to the MRA in specific matters of income tax and VAT avoidance under Section 90 of the Income Tax Act and also under Section 36A of the VAT Act, respectively. Another important point which has been touched by Honorable Attorney General is the innovations through mediation. Very, very important point. And one of the most progressive, I would say, element in that, is, and we welcome the changes introduced by this bill, is a complete overhauling of mediation, which is now governed by Section 8 of the new bill. And you will find out that under the old regime, in Section 21T of the MRA Act, mediation was limited to only one meeting. And it was almost impossible when it was conducted by the chairperson and the vice chairperson. The officers of the MRA, both the officers of the MRA and the tax representatives, could not conclude settlements in a single day, which was impossible, as I mentioned, given the very complexity and complex cases of tax cases. And given the amount of calculations and documents that are involved when revising a tax determination. And this has been putting undue pressure, you would agree with me, on both taxpayers and tax officers. Mr. the Deputy Speaker, by contrast, you will see that the Revenue Tribunal Bill enables parties can jointly opt for mediation at any point, very important point, before a hearing. And in fact, a 60-day period is granted for meaningful engagement, and a panel can be constituted for neutrality. Agreements reached are final, binding, and non-precedential. This is important to note. Most importantly, the time afforded for mediation under this new system allows both parties to reflect, consult, and negotiate meaningfully, reducing adversarial tension, very important in such litigation, and encouraging the resolution. This approach, Mr. Deputy Speaker, strengthens taxpayers' revenue authority relations, reduces litigation costs, and also restores confidence in dispute resolution process. You will note also that this time we have stronger appeals and finality, and another current law, and only errors of law may be appealed to the Supreme Court. And this time, as pointed out also by the Honorable Attorney General, through Section 11, this time, we have a more comprehensive appellate process, aligning with procedural safeguards applicable to decisions of district courts in civil matters. And now, as you know, as pointed out already, very important point, taxpayers can appeal on both points of law and facts. And this is very, very essential in tax cases. It is now a proper appeal and not a mere review. And also, it is to be noted, there is also enforcement and sanctions which have been beefed up, which did not exist. And to ensure compliance, you will see that Section 12 introduces penalties for obstruction of justice, including fines of up to 100,000 rupees and imprisonment up to 2 years. And this, in fact, Mr. Deputy Speaker, sir, this reinforces the tribunal authority and protects, very important, the integrity of the process. And precautions have also been taken to make the process, that there is a seamless transition and continuity, as pointed out by the Attorney General. The bill is not, in fact, a bulldozer. It is carefully engineered reform, and you will see that Section 18 provides for the seamless transition of all pending ARC cases to the tribunal. As a conclusion, Mr. Deputy Speaker, I would say the bill does not merely abolish the Assessment Review Committee, it replaces it with a purpose. It restores faith in tax justice, very important for this government, justice. It empowers both the taxpayer and the state. It delivers predictability, which is important in a legal system, impartiality, and also speed. In a country committed to upholding good governance, we have been hammering on this, and investor confidence, we have been hammering on that. This reform is not only welcome, it is necessary. And therefore, the Assessment Review Committee has served, it is true, taxpayers for 2 decades, but the hybrid nature, being an executive sort of tribunal, where the executive has been poking its nose to a certain extent. So it is important that this time the Revenue Tribunal is replacing the architecture with an institution that is clearly separated from the revenue-raising arm of government. And though this time, with genuine judicial muscles, disciplined by enforceable time limits, and very important, open to consensual settlement. And it is also important that we have taken all the care in order to cater for SMEs and also larger businesses. Once again, Mr. Deputy Speaker, this government is fulfilling its promises. That is, to ease the lot of taxpayers, small businesses, the government also. So it is creating in a way a very conducive business environment. Thank you for your attention.
Thank you. Honorable Attorney General.
Mr. Deputy Speaker, sir, this bill is not just about institutional adjustment. It forms part of a much wider transformation that this government is pledged to undertake. A transformation anchored in the vision laid out in the government program 2529 under the banner A Bridge to the Future. The creation of the Revenue Tribunal is a concrete step in restoring the independence and credibility of public institutions, a core pillar of our government programme. By transferring quasi-judicial tax adjudication from a body rooted in the Revenue Authority's own statute to a fully autonomous tribunal, we are progressing on our commitment to rebuild democracy and ensure justice through institutional reform. This reform also speaks directly to the programme's ambition to make justice more accessible, swift and fair, which has been one of the central tenets of my role as Attorney General. With clear timelines, transparent appeal rights, mediation options, the Tribunal will serve as a modern, responsive and accountable mechanism for resolving disputes, not in years, but in months. These are precisely the characteristics demanded in the programme's judicial reform agenda, which includes new specialised courts and simplified appeal procedures. The Revenue Tribunal embodies these objectives. Moreover, Mr. Deputy Speaker, this legislation dovetails with the public sector reform drive announced in the government programme. A more performing public service must be matched by modern legal institutions that deliver justice efficiently and equitably. Just as the economy is being rebuilt on a foundation of fair contribution and fiscal consolidation, the Tribunal provides the guarantee that the fair process and independent recourse will be available to all, especially the SMEs and ordinary taxpayers who carry the weight of national recovery. In short, the Revenue Tribunal is not an isolated reform, it is an investment in better governance. It is a visible and practical expression of the government's promise to restore trust, ensure fairness, and turn broad principles of reform into tangible rights for all citizens. I move that the bill be passed.
Seconded. Seconded by the Honourable Prime Minister.
Public Bill Committee stage.
Please be seated. Sorry.
Clause 1, short title.
The question is that Clause 1 stands part of the bill. Those in favour say aye. Those against say no. The ayes have it.
Clause 2, interpretation.
I move that Clause 2 of the bill be amended as per the amendment circulated.
The question is that Clause 2 be amended as per amendments circulated. Those in favour say aye. Aye. Those against say no. The ayes have it. The question is that Clause 2 as amended stands part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it.
Clause 3, establishment of tribunal. Clause 4, divisions of tribunal. Clause 5, staff of tribunal. Clause 6, appeal to tribunal.
The question is that Clauses 3 to 6 stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it.
Clause 7, proceedings of tribunal.
I move that Clause 7 of the bill be amended as per the amendment circulated.
The question is that Clause 7 be amended as per amendments circulated. Those in favour say aye. Aye. Those against say no. The ayes have it. The question is that Clause 7 as amended stands part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it.
Clause 8, mediation.
The question is that Clause 8 stands part of the bill. Those in favour say aye. Those against say no. Aye. The ayes have it.
Clause 9, burden of proof.
I move that Clause 9 of the bill be amended as per the amendment circulated.
The question is that Clause 9 be amended as per amendments circulated. Those in favor say aye. Aye. Those against say no. The ayes have it. The question is that clause 9, as amended, stands part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it.
Clause 10, decision of tribunal.
I move that clause 10 of the bill be amended as per the amendment circulated.
The question is that clause 10 be amended as per amendments circulated. Those in favor say aye. Aye. Those against say no. The ayes have it. The question is that clause 10 as amended stands part of the bill. Those in favor say aye. Those against say no. The ayes have it.
Clause 11, appeal to Supreme Court.
I move that clause 11 of the bill be amended as per the amendment circulated.
The question is that clause 11 be amended as per amendments circulated. Those in favor say aye. Aye. Those against say no. The ayes have it. The question is that clause 11 as amended stands part of the bill. Those in favor say aye. Those against say no. The ayes have it.
Clause 12, offences. Clause 13, protection from liability. Clause 14, regulations. Clause 15, rules. Clause 16, repeal. Clause 17, consequential amendments. Clause 18, saving and transitional provisions. Clause 19, commencement.
The question is that clauses 12 to 19 stand part of the bill. Those in favor say aye. Those against say no. The ayes have it.
Schedule.
I move that the schedule to the bill be amended as per the amendment circulated.
The question is that the schedule be amended as per amendments circulated. Those in favor say aye. Aye. Those against say no. The ayes have it. The question is that the schedule as amended stands part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it.
Title and enacting clause.
The question is that the title and enacting clause stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. The question is that I do report to the House that the Revenue Tribunal Bill number 12 of 2025 has passed the committee stage with amendments. Those in favor say aye. Aye. Those against say no. Please resume your seat. Honourable members, I have to report to the House that the Revenue Tribunal Bill number 12 of 2025 has passed the committee stage with amendments.
Public Bill, third reading.
Honourable Attorney General.
I move that the Revenue Appeal Bill number 12 of 2025 be read the third time and passed.
Seconded. Yes, seconded by... The question is that the Revenue Tribunal Bill number 12 of 2025 be read the third time and passed. Those in favor say aye. Aye. Those against say no. The ayes have it. So we break for 35 minutes.